So friends, as you probably know, Special Counsel Jack Smith asked Judge Tanya Chutkan to order Donald Trump not to threaten, intimidate, or harass the witnesses against him. Well, Donald Trump's defense attorneys just filed their reply, and they seem to suggest that Donald Trump has a First Amendment right to threaten, intimidate, and harass the witnesses. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as you probably know, Special Counsel Jack Smith filed a motion with Judge Tanya Chutkan in federal court in Washington, D.C. Judge Chutkan is presiding over Donald Trump's January 6th trial, the one in which he is charged with multiple crimes for trying to overturn the results of the 2020 presidential election. And in the motion that Smith filed, he is seeking some narrowly tailored restrictions, some limitations on Donald Trump's speech and on his posts, seeking to prohibit Trump from doing things like threatening, intimidating, harassing, or endangering witnesses, judges, prosecutors, jurors, or their respective family members. And they're also seeking to prohibit Donald Trump from saying things that are pretty transparently designed to poison all future jury pools. Well, now, Donald Trump's lawyers have filed their reply. And frankly, it reads like a cross between an extended tweet and a Trump campaign ad. First, let's start with the new reporting. This from Kyle Cheney of Politico. Headline, Trump urges judge to reject proposed gag order in federal election case. And that article begins, Donald Trump's lawyers said Monday that a gag order proposed by prosecutors would unconstitutionally silence him during key months of the 2024 presidential campaign, urging a federal judge in Washington, D.C. to reject the proposed limits. In a 25-page filing that mirrored some of Trump's own heated political rhetoric, Trump's attorneys said the former president's attacks on potential witnesses, Special Counsel Jack Smith, and even U.S. District Court Judge Tanya Chutkan herself are protected by the First Amendment and were not actual threats or incitement of attacks. This quote from the brief. The prosecution may not like President Trump's entirely valid criticisms. Attorneys Gregory Singer, John Lauro, and Todd Blanche wrote in the late-night filing, but neither it nor this court are the filter for what the public may hear. Smith's team sought the gag order earlier this month, citing Trump's recent inflammatory attacks on potential witnesses in his upcoming trial on charges related to his bid to subvert the 2020 election. They also cited his attacks on prosecutors and Chutkan, as well as on figures like Mike Pence, who is expected to be a key witness in the case. Prosecutors want Chutkan to order Trump to refrain from further attacks or risk punishment. They are expected to reply to Trump's filing later this week. Okay, friends, before we dig into this topic, let's just read the opening salvo of the reply that was just filed by Donald Trump's attorneys that seems to suggest that they believe Donald Trump has every right to harass, intimidate, and threaten witnesses and others. President Trump respectfully submits this response in opposition to the prosecution's motion to impose unconstitutional prior restraints on President Trump's political speech. On August 1st, 2023, the prosecution publicly released a 45-page speaking indictment that read very much like a campaign press release. As if the indictment's media talking points were not enough, prosecutor Jack Smith then held a press conference to deliver an incendiary attack upon President Trump, falsely claiming that he fueled an unprecedented assault on the seat of American democracy. This inflammatory rhetoric, which violated long-standing rules of prosecutorial ethics, was then repeated daily by media publications across the country. Following these efforts to poison President Trump's defense, the prosecution now asks the court to take the extraordinary step of stripping President Trump of his First Amendment freedoms during the most important months of his campaign against President Biden. The court should reject this transparent gamesmanship and deny the motion entirely. And friends, it goes on like that for 24 more pages. As I say, it reads like a combination of an extended tweet and a Trump campaign ad. But I want to take on just two things that highlight the frivolity of what Donald Trump's lawyers are claiming. Here's the first. Donald Trump's lawyers tell Judge Chutkan, you can't limit Donald Trump's speech at all. Not in any way, not in the slightest. So if I were Judge Chutkan, I would ask Trump's lawyers, oh, so you're saying that Donald Trump can harass, intimidate, and threaten the witnesses. Is that what you're saying? The lawyers would have to say, well, no, Your Honor, we're not saying he can do those things. Oh, then I can limit his speech. I can prohibit him from threatening, from harassing, from intimidating the witnesses, because you agree he can't do that. So obviously there would be nothing improper about me ordering him not to do that. That's the first point. But here is the second and probably more important point. When you're on pretrial release, as Donald Trump is, he's on pretrial release in 4 felony cases, 2 state and 2 federal. When you are on pretrial release in a felony case, guess what? Your rights are diminished. How so? A judge could order you to surrender your passport. Judge can't order just any old person to surrender their passport, but a judge can if you're on pretrial release in a felony case. A judge could order you to abide by certain travel restrictions. Judge could tell you you can't leave the District of Columbia. Judge could tell you you can't come into the District of Columbia except to attend court or meet with your lawyers. Judge can't order any old person to travel or not travel certain places that might violate somebody's Fourth Amendment right against unreasonable restrictions, unreasonable seizures, maybe your equal protection rights to travel interstate. But when you're on pretrial release, your rights are reduced. Think about Donald Trump's foot soldier, the leader of the so-called Proud Boys organization, Enrique Tarrio, who's now doing a couple of decades in prison for listening to Donald Trump's command to attack the Capitol and stop the certification. He was ordered to stay out of the District of Columbia. Why? Because he was on pretrial release. Of course, he was convicted for what happened at the Capitol on January 6th, what his fellow Proud Boys did, even though he was not even in the District of Columbia on January 6th. He didn't go to the Capitol personally, but the point is the judge can absolutely order all sorts of restrictions when you're on pretrial release because your rights are diminished. A judge could order somebody to engage in weekly drug testing if they're on pretrial release. A judge could put somebody on a curfew if they're on pretrial release. A judge could order somebody to be electronically monitored, GPS, wear an ankle bracelet when you're on pretrial release. Why? Because your rights are reduced. And ultimately, a judge can order somebody detained pending trial, jailed pending trial, while in a pretrial status. So of course, a judge can also put some narrowly tailored, reasonable restraints and prohibitions on Donald Trump's speech and on Donald Trump's posts to prevent him from harassing, intimidating, and threatening witnesses and jurors and judges and prosecutors and anybody else involved in the court system, involved in the process of holding Donald Trump accountable for his crimes. And he can also be prohibited from saying things that are designed to infect the jury pool. And nothing Donald Trump's lawyers say to the contrary will be persuasive, I believe, to Judge Chutkan. And when this litigation concludes, because as of right now, Jack Smith asked for the restrictions, Donald Trump's lawyers opposed the restrictions. Now, Jack Smith, I think, has a few days to file a response to the motion or to the response that was just filed by Trump's lawyers. And then I suspect it's going to be set for an oral argument, probably in the next week or so. And I believe there will be a pretty prompt resolution of this by Judge Chutkan. And if I had to bet, $1 is my betting limit. I'm not a high roller. I would put the full buck on Judge Tanya Chutkan imposing appropriate, lawful, constitutional, narrowly tailored restraints on Donald Trump's dangerous speech and posts. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.